Welcome to Tax Sale Insiders, the latest from Tax Sale Resources, bringing you information about tax sales from experts in the industry. We interviewed Matthew Roth of Allen, Vellon, Wolf, Helfrich & Factor PC based in Denver, Colorado. Matt has been practicing real estate law for 25 years and also has worked for a developer, so he knows the world very well. In this episode, Matt shares with us the in-depth process of treasurer deeds in the great state of Colorado and how simple it can be in comparison to other states. So sit back and relax for another episode of Tax Sale Insiders, powered by Tax Sale Resources.
Well, hi, everyone. Welcome to this episode of Tax Sale Insiders. I'm Brian Seidensticker, CEO of Tax Sale Resources. And with us today, I actually have Matthew Roth. Matthew's an attorney from Colorado with Allen, Vellon, Wolf, Helfrich & Factor, a firm out of Denver. And Matthew is one of the few attorneys in the state of Denver or state of Colorado that actually have some experience dealing with treasurer's deeds, as they call them out in Colorado. Well, thank you, Matt, for joining us.
I'm glad to be with you, Brian, and I look forward to this.
It's one of my first questions, favorite questions I always ask is really how what is your background? How did you get in the industry? And I chuckled when you said you're excited because you really have to have kind of a twisted mind to get excited about tax liens, but I'm certainly in that boat. But anyway, give us a little background on yourself.
So I've been a practicing attorney for about 25 years. I specialized in real estate. I got my start in real estate before ever going to law school. I used to work for a real estate development company in the Chicago area. So I learned about some aspects of real estate marketing, operations. I worked for specifically a home builder. We did multifamily, single family, and some small commercial projects. And then I worked there for 3 years. And then started thinking about going back to school and getting my law degree. So I went to law school, went to St. John's University in New York. And then after I graduated, I moved to Colorado and started working. And with real estate as my reference point, I've just always kind of gravitated towards areas of the law that involved real estate, whether that be residential, commercial, real estate litigation, transactional, and foreclosures, and even tax lien matters.
Got it. Yeah, so jack of all trades in the real estate arena, with tax liens being one of those trades.
Yes, exactly.
Got it. Well, it's I guess before I dive into a little bit, Matt, for those that are watching, Matt wrote what I consider kind of the perfect white paper. It's short and sweet, but for those that want to read it, it's called the Colorado Tax Lien Purchase. It's about 6 pages. Does a great job of explaining the basics of how liens in Colorado work. And the beauty of Colorado that I learned after reading this, Matt, is it's actually much more simple in Colorado compared to a lot of states out there, which is great. But I guess dive into some of those basics. I guess at the very heart of it, do you consider Colorado a tax lien state or a tax deed state or any sort of weird hybrid? What does Colorado fall under?
I would consider it a tax lien state. As you mentioned, the process is relatively simple. Now, I don't know all the other jurisdictions, but I think for the most part, and this applies to a lot of other aspects with Colorado laws, that it's more user friendly, if I could use that term. It's not so complicated. The tax lien process is what I consider fairly straightforward.
Yes, and I would agree with you. Some states have very complicated statutes, and it's very, very difficult to keep track of what you have to do when and so forth. And at least from my understanding, Colorado is not easy. I mean, none of this is easy, but it's easier than some of the states out there. I guess kind of back to the basics. When do those auctions typically occur in Colorado?
I guess give me a little more specific. When do those options?
Are they in the fall, year round? Are they in the spring?
Okay, so there's a tax lien sale, and that occurs in November or December. It depends on the county, but it's once a year, and it's late November or early December. And the way Colorado has it set up, it's each county has it set up online, so it's an online auction process.
Okay, and then since it's online, you don't have to plan on traveling. I guess as far as the bid style, is it I'm assuming is it a premium bid, or is it a bid down interest? How does that work?
You can bid a premium. Typically, you bid for whatever the amount of the lien is, but if it's if there's other bidders, you would seek to increase your bid amount, which would include a premium. But the premium, I should mention, that is not something that you can earn interest on or collect. It simply is a way to lock up or increase your chances of obtaining the tax lien.
And then if that lien doesn't redeem, then you don't get that money back ever, right? If you go forward with the treasurer's deed at the end.
Correct.
Okay. Now you mentioned the interest, so let's just hit on that real quick. So how does the interest work in Colorado?
It is 9 points above the Fed rate, and it's as of whatever the Fed rate is. I believe September 1st of that year.
Okay, so right now that Fed rate is very low. I'm guessing like 0.25%. So that interest is 9.25%, or do they go 9 or 10? Is it whole?
Yeah, it's a full percent. So whatever the Fed rate is, rounded up to the nearest full percent.
Okay, so right now it's basically 10. Would that be right? Okay. And then is that compounded monthly, daily? How often are they calculated?
That's compounded monthly.
Okay, so is it at the end? Is it at the first of the month, or is it on the date of whenever the sale? Every 31 days or every month after that?
That's a good question. I'd have to look at that. I think from what I recall, it's compounded monthly at the end of the month, but that's something that I would just have to look at to verify.
It may actually vary by the county, just depending on how the county wants to interpret that.
Yes.
Okay. Now, you mentioned there's no interest on the premium. So if it's a $1,000 lien earning, let's use simple math, you're earning that 10% a year. If you happen to bid an extra $1,000 on that property, you essentially have cut the effective interest in half down to 5, right? Because you're not earning any interest on that premium.
Correct.
Got it. Okay. And then how long is the redemptive period from the time of the auction till the time that nobody can redeem that lien any longer in Colorado?
That period would be 3 years. So you receive a certificate of purchase if you are the winning bidder of the tax lien, and then after 3 years, as the tax lien holder, you would then have a right to apply for a treasurer's deed to seek title to the property.
Got it. So 3 years, and then does that vary at all by property type or anything like, or homestead versus non-homestead, or is it just flat 3 across the board?
No, it's again fairly straightforward. It's a 3-year period, and it applies across the board.
Okay. Okay. Now, is there anything that's required of the investor from the time they attend the sale till the end of that 3-year period? Is there any noticing that you have to do after the sale? Do you have to record the lien? Do you have to do really anything in that time period?
No, you're like I said, you are the holder of the certificate of purchase, so there's nothing that you have to do to protect your lien rights. You do have the opportunity to buy subsequent year taxes for that property if they remain unpaid, so you can further secure your interest in that particular property. That would be referred to as subtaxing rights. So if I was the investor, I was the winning bidder, was the holder of a tax lien, then the following year, if those taxes on the property were not paid, I would then have the right to buy that tax lien for subsequent years, and it would earn interest at the same rate as the rate of the original tax lien that I hold.
Okay, so not if there's a big adjustment in the Fed rate, that would not be they're not going to affect. It's whatever the original lien purchased rate is, you would get that on the new lien.
Correct.
Okay, got it. Is there, I guess the 3-year redemption period, or the end of that redemption period, that's kind of the first time you have the right to apply for a treasurer's deed, but can you go beyond that? I mean, do liens stay valid more than that 3 years?
Yes. So you're the holder of the certificate of purchase. You hold that tax lien, and there's a 15-year statute of limitations for you to seek to enforce your rights under that tax lien. So you could, after 3 years, you could then apply for a treasurer's deed, but you have up to 15 years to enforce your rights and to seek to apply to get a treasurer's deed.
Got it. Okay. So you can, within, after the 3rd year, but you have 15, so you can wait for a long time if you want to, or there's some need to do so. And you can, at any point in time, you can then apply for a treasurer's deed after that 3 years and before the 15 years. Now, is there any nuance as to you have to be done with the process and a treasurer's deed in hand within that 15-year period, or as long as you apply for it by that 15-year period, you're good?
Again, I've never encountered that. My sense would be, as long as you applied for a treasurer's deed within that 15-year statutory period, that would preserve your right.
Okay, so most likely, as long as you apply, but definitely check with the county before counties can vary from one to the next, and some may be more amenable than others. And the worst thing you can do is make an assumption and then have to deal with that headache after making that assumption, right?
Exactly.
Yeah,
exactly.
We all know what assume does to you and me.
Yeah. Yes, well put.
All right. Now, as far as that application, or I'll say foreclosure process for that treasurer's deed, describe that a little bit to me. I mean, how does that work? I guess, do you basically send in a piece of paper that says send me a deed, or is there more to it than that?
So you have the certificate of purchase. So you would file an application seeking for the county to issue a treasurer's deed, and you would submit a copy of your certificate of purchase to provide the county with verification that you're the holder of the tax lien. Okay. So it's just it's an administrative process, and each county, I don't know if some counties require certain forms, but it's, again, a relatively straightforward process where you file your application seeking a treasurer's deed.
Okay, so you send this application with a bunch of required information along with the certificate, and then are there other fees or taxes, et cetera, that you have to send? Like, is there an additional amount due? For example, if you chose not to pay the subsequents, you have to pay that. If there's previous liens, you have to pay that. Like, is there an additional amount that you got to make sure the property is, I'll say, clear of any open taxes when you apply for that?
No, so when you apply for a treasurer's deed, I think there are certain administrative fees that the county tax on. I think those are marginal. But you're not required to pay any other additional taxes or anything of that kind. Again, it's just filing the application and whatever fees the county tax on for administrative purposes.
Okay, so you don't necessarily need to pay the other taxes that are due, but they'll still be due at that point in time.
Yeah, correct. So I guess if we walked through that, if you applied for a treasurer's deed, and they issued you a treasurer's deed, then that would show that you are now title owner of the property, but that property may be subject to subsequent taxes or liens for unpaid taxes.
Okay, got it. So it's not like those are wiped out. Whatever's due for taxes is still due, whether they're 5 years old or subsequent taxes since the time you attended the auction.
Exactly.
Got it. Okay. Now, that brings up an interesting scenario. So if you, with this 15-year right that you have, if somebody else bought a lien, let's say 5 years ago, and they chose not to do anything, and I bought the lien, 3 years ago, I chose to go forward with the treasurer's deed. I have that in hand, but that prior lien is still out there, right? They still have the right to foreclose on it over the top of the treasurer's deed that you have. Is that right?
Again, I've never encountered that scenario, but looking at that and analyzing it, that prior lien for taxes would still be valid. So if someone bought that lien, that would be an encumbrance against the property. And even though now you, let's say, have a treasurer's deed to the property, giving you title to the property, your property rights would be subject to that prior year tax lien.
Got it. Interesting. So it's certainly suggests, although not required, certainly suggested that when you get that treasurer's deed, you go look to see if there's any prior taxes or lien amount or liens open and make sure those are taken care of. Otherwise, you may end up forfeiting that treasurer's deed as well if they chose to move forward with their application.
Correct. Yeah, those, and I guess the way to look at it is, with taxes, they never go away. Mm-hmm. So if you're, buying your tax lien, if you end up receiving a treasurer's deed giving you title to the property, there could be outstanding taxes that have attached to the property that you're going to have to deal with. Got
it. Okay. Well, that's definitely interesting scenarios that can arise. So it's always good to know what other stuff is sitting out there on each lien. Now let's talk about the title a little bit on the treasurer's deed. Once you get it, is it a clear title, meaning you can go get title insurance for that, or is there any additional process you need to go through in order to get to that state?
So once you receive a treasurer's deed, title companies do not deem that your title is marketable. So if you now, as owner of the property, sought to sell or transfer the property, you're going to have to deal with that issue of having unmarketable title, which what you will have to do to obtain marketable title is commence a quiet title action.
Okay, so to get marketable title, you still need to file that quiet title action after you have that treasurer's deed in hand.
Correct. Title companies, the way they look at it is if you're the holder of a treasurer's deed, that title is unmarketable for a period of, I believe, 9 years. So if you held the treasurer's deed, didn't do anything with the property, allowed 9 years to pass, I guess after that point, maybe a title company would say, okay, you've held the property for long enough. And by virtue of that, we would insure it. We believe now the title has become marketable because so much time has passed and there's been no claims against the property. But 9 years is a fairly long time to just sit on your, sit holding your property. If you, again, wanted to try to convey or sell that property after you receive a treasurer's deed, the process would be to commence a quiet title action, which would then give you marketable title. So then it would give you the freedom to sell or transfer or convey that property however you saw fit.
Could you convey it via a quit claim deed without having to go through quiet title?
Certainly. So a quit claim deed just passes title, whatever title you hold, to whoever you transfer it to.
Mm-hmm.
So whoever receives the property receives whatever rights that you had, which means that they would receive it, but the title would still be marketable. So the person receiving the property, if they then wanted to turn around and then sell or convey that property, they're going to be stuck with the same issue that title is not marketable.
Got it. So the buyer would certainly need to be aware that that they're going to have this additional step that they go through in order to get marketable title on their end.
Exactly.
Got it. Now, is there I'll speak possession wise. So you have a lien, now you have a treasurer's deed, and it's an improved property, and there's still somebody living in the home. As far as possession goes in Colorado, what additional steps would you have to go through in order to obtain possession of the property?
So if you're the holder of the treasurer's deed, you're the title owner of the property. So you would have the right to evict if there is someone who is in possession of the home or the property. So you would institute a forcible eviction and detainer action.
Okay, so you do have the right to go through that process with the treasurer's deed in hand. Got it. Okay. Now, as far as the time it takes from when you apply for that treasurer's deed till you actually have it in hand, how long does that typically take?
It typically takes about 3.5 years. As I said, there's a 3-year period before you can apply to obtain the treasurer's deed, but then I tack on about a 6-month period, more or less, for the county to issue that treasurer's deed. It's not an overnight process. You apply for the treasurer's deed. Notice again that has to go out to the owner of the property who has failed to pay the taxes, giving them notice that a treasurer's deed has been applied for. And then each county is a little different, but generally speaking, it's about a 6-month period before they will issue a treasurer's deed.
Okay. So, and is there any opportunity to, knowing that it takes 6 months, is there any opportunity to actually apply for the treasurer's deed before the end of that 3-year period, or do you have to wait until the end of that 3 years to even apply?
Yes. So you can, before the 3-year period, you can apply several months in advance of that period. And it's kind of a county by county basis. Some counties realize that there is this lag time or delay, so they'll facilitate that and allow you to apply early. And other counties, it remains to be seen how they'll handle that, whether they'll require that an application not be submitted until the 3-year period has occurred, or whether they'll accept an application for a treasurer's deed in advance of that 3-year period, knowing that there's going to be kind of a lag.
Got it. So ask the county, if you.
Exactly.
Okay. Got it. Now, I guess I'm going to take a little step back to the title issues. And so as you apply for that treasurer's deed, are there any liens that are extinguished as part of that application process? And what I mean by that is, like, do mortgages get wiped out, or do they stick with the property? Do mechanics liens get wiped out, or do they stick to the property? What happens to open liens on the property?
So those open liens would get wiped out.
Okay.
So a mortgage, mechanics liens, those would all be wiped out through this tax lien process and the issuance of a treasurer's deed. Any lien holder should be given notice, so they would have they'd have the ability to protect that lien by paying off that tax lien to preserve their mortgage or lien.
Okay, so that's part of that 6-month process, is the county will do the notification.
Yes.
They have the right to do what they need to within that 6-month period. And then assuming that they do, then it gets redeemed, you get your interest back, you move on. If they don't, they get wiped out, you get your treasurer's deed, and you move forward from there.
Correct.
Got it. Now, I know some states, there are some exceptions to that rule. 2 biggest ones would be probably, as far as lien goes, like an IRS lien. I've heard those actually stick and don't get eliminated. Is that the same way in Colorado?
And again, I've never encountered a situation where I've had to deal with a federal tax lien, but I would err on the side of caution. Generally speaking, federal tax liens don't get wiped out, and I'm using an analogy of other matters that I've dealt with that don't involve tax liens, but did involve liens to the IRS, where they didn't get extinguished or wiped out through some type of foreclosure or process where other liens were cleared. And there's always special rules or special conditions that seem to apply to the IRS that they require, for example, specific notice. For example, I know that I believe under the foreclosure statute, parties can just receive notice via regular mail, but I think you have to give notice to the IRS by certified mail, for example. And if you don't, then their lien is unaffected. So there's always, again, this is kind of my view and kind of a word of caution, is when you're dealing with the IRS, they seem to, the rules seem to be weighted in their favor. So dealing with the IRS, always be cautious and think that their lien is going to remain and not be extinguished.
Got it. Yeah, like I said, err on the side of caution. You never know, you might get lucky and they just don't enforce that in the end. But if you come across it, don't assume it disappears, I guess is the key, right?
Yes, that's how I would that's the advice I would give.
All right. Now, as far as bankruptcies go, is Colorado similar to other states where if the property owner files for bankruptcy, it basically puts everything on hold until that works through its process?
Yeah, so a bankruptcy, with any bankruptcy, there's an automatic stay provision, which means you can't move forward with your action to clear, any other subsequent liens. So if a bankruptcy was filed, there would be an automatic stay. As the lien holder, you could file a motion with the bankruptcy court seeking to be exempt from that stay. So again, it just involves another process through the bankruptcy court, which, as a lien holder, you have secured rights in the property, and the bankruptcy court would allow you to, or exempt you or release you from the bankruptcy stay.
Got it. Okay. All right. And then I guess general time frame speaking, you mentioned 3 years, the redemption period ends, another roughly 6 months to get that treasurer's deed. You might be able to shorten that, by applying a little early as opposed to waiting the full 3 years. And then if you want actual insurable title, you got to file for a quiet title action. So how long does that quiet title action typically take in Colorado?
I would typically say that it takes about 6 to 9 months to perform a quiet title action. And that's based on if it's uncontested. So if it's uncontested, meaning that no interested party is going to challenge your rights to seek to obtain clear title. If it's contested, then it could take who knows how long. It depends on what the legal issues are, what the claims are, and it could turn into any lawsuit, which is things slow down, and you could be looking at a year or more in terms of trying to perform this quiet title action, knowing that there's someone who's contesting your rights.
Got it. So another, yeah.
But I guess, what the takeaway is, it's about a 6 or 9 month process to do a quiet title action if it's uncontested. And I would say the majority of any type of quiet title action is going to be uncontested. Got it.
Okay. Yeah, because I understand it. It can vary wildly if you've got a boatload of heirs that you have to try and find and notice, and if any of them contested, obviously that drags it out as well. But in general, if that's uncontested, roughly 6 to 9 months.
Yes, exactly.
Got it. Okay. Now, as far as I'll say redemptibility, if that's even a word, but the prior owner or the another lien holder or a person of interested party in that property wants to redeem that at any time, right? They obviously can go and redeem it for the open taxes plus additional interest and fees for that 3-year period. Once you apply for that treasurer's deed, do they have the right to redeem basically the same way at any point until you have that treasurer's deed in hand?
Yeah, so at any period during the 3 years, any interested party could seek to pay off the tax lien and preserve their right, either the prior owner's right or a lien holder's right could seek to preserve their interest. After the 3-year period, you apply for a treasurer's deed, and the prior, or the owner, or as I refer to them, the prior owner or any lien holder could seek to redeem, again, trying to preserve their rights to the property to pay off that tax lien. So they have, 3 years, and then an additional period after you apply for the treasurer's deed. It's their, I guess, one last chance where the county would give them notice that now the tax lien holder is seeking to obtain a treasurer's deed and own title to the property, which would mean their lien would be extinguished. It gives them the last chance to redeem and preserve or protect their lien rights or their ownership rights.
Got it. And now, is the interest still earning during that roughly 6-month period?
Yes, correct. So there's interest is accruing during the entirety of that period, from during the 3-month or the 3-year period at any time thereafter.
Okay. And then, after you have that treasurer's deed in hand, I guess there's still the opportunity for the prior owner to object to that, but it's basically, that's a court case at that point in time, right?
Exactly. And at that point, their rights have been compromised or diminished, so they had their chance, and unless they have some valid claim, you would think that after that period, you're just dealing with a claim, but it would be a legal action to defeat that claim.
Got it. Now, would you say the courts in Colorado are fairly prior owner friendly or investor friendly, as opposed when it comes to, I know every case is different, but I know some states are much more, if there's any claim to that property from a prior owner, they will always err on the side of giving it back to the prior owner. And then there's some states that are more err on the side of, well, you've had multiple chances up to this point, they go on the side of the investor most of the time. Does Colorado have a side they typically go with, or is it every case by case is different?
You know, I would think that the it's an unbiased process, so the courts pretty much, you know, look at the statute and say you've had your uh, opportunity to pay off that tax lien, you've had your opportunity to redeem, uh, and you know we're going to follow what the statute says and vest title in the lien holder, the tax lien holder. But you know, from county to county, you could have you know, maybe more sympathy in terms of the owner of the property or the prior owner. You know, based on whatever arguments they could make, they could certainly appeal to the sympathy of the court that they, you know, didn't receive proper notice or something along those lines, and seek to make a reasoned argument, and you know the courts could be sympathetic to that. But I think the courts, I don't think there's a bias for or against owners or investors. I think it's a pretty straightforward process, and at least I'd like to think that the courts are going to simply enforce the law as it's written.
Okay, so they're in general very, very reasonable, right? They look at the facts. They're not going to look at oh, nope, you didn't dot your I on this document, it wasn't proper notice. They're not going to go to that extreme one way or another.
No, I don't think so. And I think there's you know, sufficient safeguards that the statute is built in. Again, it's a 3-year period, and even additional time is given after that, after the treasurer's deed is applied for. So, and I think, you know, it's the duty of a property owner to be diligent about, you know, claims affecting their property or failing to pay taxes. So I don't think the courts are going to, you know, bend over backwards to try and accommodate you know, someone who has failed to pay their taxes. Again, there's been an opportunity to preserve their rights, and you know they're going to simply apply the law as written.
Got it. Got it. Excellent. Well, I guess Matt, when do investors typically engage you for help? I mean, is it do they reach out before they ever kind of enter the state to ask some general questions, kind of like we've talked about here, to get an understanding? Or do they, you know, is that rare and they really only engage you, you know, if a quiet title action is needed, or if there's, you know, someone trying to, you know, fight, you know, the treasurer's deed, if you will? Because when do typically investors reach out to you?
Investors, you know, could get in touch with me or seek my advice at any point, either prior to, you know, bidding in the auction, if they want to familiarize themselves with the process or have any questions. In terms of kind of active representation, I would think that typically I get involved with clients who have issues affecting the property. So let's say an investor was a successful bidder, they're the holder of the tax lien. It's, you know, they're waiting for that 3-year period to expire so that they can apply for a treasurer's deed. And maybe they would engage my services at that time when they apply for a treasurer's deed, or during that time where they hold the tax lien, and maybe they want to sell that tax lien to someone else, or they want to convey it. You know, it's always best to have an attorney involved in any kind of assignment of a certificate of purchase or the like. And then certainly if they do obtain a treasurer's deed and they're going to need to get marketable title, they would need to engage an attorney to commence a quiet title action. So that's where I would, you know, be the most useful or be able to step in and help, is when they need to file a quiet title action. And then obviously if there are any issues, legal issues affecting their rights as a tax lien holder or the holder of a treasurer's deed, if there's another lien out there or another party claiming an interest in the property, and which could cloud title, so they would need to have an attorney try to defend or protect their rights to the property under the tax lien statute.
Got it. Got it. Okay. But I appreciate, because your answer actually reminded me of a couple questions. So one is you mentioned, if a investor wants to transfer their lien, and basically the question would be, can you actually sell, tax liens on the secondary market? Meaning, I went to the auction, I bought that lien, I no longer want that lien for whatever reason. Sounds like I do have that option of assigning that or selling that lien to a third party, correct?
Correct. So you're the successful bidder at the auction. You receive a certificate of purchase. That's evidence of your rights to the property or the rights to that tax lien. And you can sell that or convey it. You can convey it to a trust or sell it to an individual or an entity. And that would simply be the way you do that is through an assignment of that certificate of purchase.
Got it. Got it. And then I guess kind of last question. So the liens that, obviously the assumption is they all sell at the auction, but it's inevitable there's going to be some liens that don't sell at that auction. What does the county do with those? Do they just hold them and sell them the next year? Are they available to purchase directly from the county? I call over the counter at any time. Like, what happens to those?
Yeah, so those tax liens are held by the county. They are then sold in subsequent years. But if no one bids them or bids for them, then the county, you could deal with the county directly to try and purchase those liens. And that would just, kind of be, like you said, referred to it as over-the-counter purchase.
Got it. Okay. Now, Matt, do you foresee any changes coming down the pipeline, statute-wise, that would fundamentally change how Colorado functions from a tax lien sale standpoint at all?
No, I don't. The system has been in place, I don't know how many years, but this statute has been in effect for quite a while. The parties, counties, treasurers are familiar with how the statute works. So there's been no, no feeling that the process or the system needs to be changed or tweaked. So it's a system that's in place, and I foresee that it'll continue to be in place as it is for the foreseeable future.
Got it. It's fairly stable compared to some states are changing quite a bit. Colorado's pretty stable.
Yes.
All right. My last and second favorite question, after asking how people get into this or fall into this industry, but my second favorite question is just, related to pitfalls, right? Typically there's general pitfalls that are pretty easy to avoid if you are aware of them. Every state is a little different. But is there a biggest pitfall or pit hole or top two maybe in Colorado that you're aware of that are pretty easy for folks to avoid if they knew about them?
The biggest drawback or pitfall, as I see it, is you just don't know what you're buying in terms of the property. And I use the analogy that it's like investing in foreclosures. So you buy a property at foreclosure, you don't know the specifics of the property. You don't know what defects that the property may have, if there's any environmental contamination. So you end up buying a property at foreclosure and then finally doing an inspection and finding out that the property has a much less value than you expected or thought, or has no value. The same with a tax lien. You're buying an interest in a property and you just don't know the details of the property. And the idea is, if someone hasn't paid taxes on the property, they haven't put any money into the property for years, so there's going to be deferred maintenance. So if you end up with the property through a treasurer's deed, now you're the title holder of the property. Now is your opportunity, or you find out you know, the details of the property, and you could find out that it's in severe disrepair. You know, it needs lots of maintenance and improvements, and so that's just the you know, the pitfall as I see it is you don't know the specifics of the property, and so you're taking that risk. The flip side is you're buying a tax lien for what you believe is a small amount, and you could end up holding title to the property, which could be a much greater amount. And so that risk analysis, you can justify that risk analysis.
So it's do your due diligence. I hear that on a regular basis. Know what you're buying. Don't just assume based on the amount or the fact that they're selling it that it is a property of value. They'll sell a lien really on anything, and you may end up with a larger headache if you don't do your research. So research on know what you're buying.
Exactly.
Got it. Well, Matt, I greatly appreciate your time today. Thanks for joining us. I know everyone watching this will appreciate your insight, and they know how to contact you. We'll put that information up here shortly, but they'll know how to contact you going forward. So thanks again.
Well, thank you. I appreciate it, Brian. And I would just say to anyone out there, if you have any questions, I would be more than happy to talk to you.